And he's on probation out of Shiawassee County, and so he is hoping to get it so that he can test. He's testing in Shiawassee County and has signed a release of information. So he's hoping to be able to continue doing the testing there and not have to drive the hour.
We're opening with a courtroom already dealing with serious uncertainty, a bench conference, questions surrounding a defendant's location, and a probable cause hearing pushed back. Then bond becomes the immediate issue. This docket quickly turns into a battle over custody, appearances, restrictions, and fairness. Subscribe for more dramatic courtroom breakdowns.
All right, record should reflect we've had an extensive bench conference in this case, and I'm not even at this point going to say what that's about. It's about the defendant's location. I'll just put it that way. And I will adjourn the probable cause conference out 1 week to the June 11th, 2026, 9 a.m. Bond will, at this time, will continue.
Thank you, Your Honor.
Thank you. Come back. There we go. Court does call the cases of the people versus Christopher Madison.
Ready,
Judge. Court shall cease to assistant public defender on behalf of Mr. Madison, who could be in custody.
State your Christopher.
Yes,
State
sir.
your name.
Christopher Jerome Madison.
Thank you, sir.
Thank you, Judge. I did have to speak to Mr. Madison a few times over the last few days. His primary concern was he wanted me to address his bond. At this point, we're not ready to proceed, so we'd be asking for an adjournment and for me to address his bond, Your Honor.
And do what?
And he wants me to address his bond.
All right. I'll adjourn it to June 18th, 2009 a.m. as to bond.
Thank you, Judge. Mr. Madison did indicate that he missed a court date, I believe, and that's why why he was put into custody. He'd be asking the court to consider changing that and allowing him back out of custody. He says that he could afford to pay the bond, but he doesn't have anyone who can go get his money and bring it to the jail to pay it for him. So he's asking the court if the court might consider reducing his bond and possibly a PR bond. He did indicate that I believe he lived at the Defendant Center prior to being incarcerated. And so I think that's all he wants to address today, Your Honor, and leave it there.
Any response from the people?
Court's discussion should given
Well, a couple things. Didn't appear, and then how did he come back into custody?
Right. He was picked up, Judge. He did not turn himself in.
He was picked up. He did not turn himself in. I'll reconsider it on the 18th, but at this time, motion for bond reduction denied.
Thank you, Judge. Good morning.
Court calls case people versus Joshua Freeman.
Your Honor, the practice pursuant to Michigan Court Rule 8.120 under the supervision of Forensic City Attorney Ashley.
Where are you from?
Ireland.
Yes, all right, good. Permission.
Oh, that's auto. Then it's automatic.
Yeah.
David I. Goldstein appearing on behalf of the defendant.
Jay Shuri, Freeman.
Thank you. You're requesting an adjournment?
Yes, Your Honor. We have the written discovery, but I just got the videos yesterday, so we need an opportunity to review them. The date that I'm going to be back from vacation is July 2nd.
That's what I tried. All right. I'll adjourn the matter to July 2nd, 2026, 9. Bond continued. All right. Thank you, ma'am.
Oh, I'll do it.
The court does call the case, full state of Michigan versus Elijah Hudson.
On behalf of Your Honor.
Mr. Burkett, can you state your appearance, sir?
Yeah, Raymond Burkett on behalf of Mr. Elijah Hudson. Thank you.
Your name?
Elijah, will you introduce yourself to the court?
He did.
Oh, okay. Yeah.
What
I'm
are we
sorry.
doing?
Okay, Your Honor, at this point, we filed for ask this court to do a competency to stand trial and a criminal responsibility. Based on my conversations
So
with
you're
counsel.
asking forensic evaluation?
Yes.
I
Competency,
would need I will set it. I'll need the orders in to the court. So forensic evaluation is ordered. I'll set a competency hearing for
September 3rd.
September 3rd, 2026, 9 a.m.
thank you.
Bond at this time will continue. Thank you. Michelle, is this okay? Court does call the case of the people of the state of Michigan versus Svid Kishan.
And then we have people.
Brian stepped out.
All right. While we're waiting for him to come back, can
I don't
counsel?
know how you want to proceed, whether you want to address the bond violation first or the adjournment first.
Why don't we address at least tangentially the bond violation first? And then,
Your Honor, at this time, the people would be asking for the defendant to be placed on the GPS tether within open to the victim's residence. The people have learned further information about this bond violation, would like to do some further investigations. I think at this time, our request will be to add that bond condition of the GPS tether.
all right.
Your Honor, I'm going to make a somewhat mild objection, but first I want to address the fact that my understanding is there's already a bench warrant. So if there is, I'm asking that it be canceled. I don't know if it was ever signed. I know.
Yes, it was signed.
Now, the court faces a tricky bond decision. The prosecution wants a GPS tether, while defense argues there has been no contact with the complainant since the alleged voicemail. The judge cancels the warrant, but adds an exclusion zone around the victim's residence. Was this a fair middle ground here?
Off on, and I think entered, was it not? All right. So what I will do, he's here, so I'm going to cancel the bench warrant.
With regard to the GPS tether, Your Honor, just very briefly, my understanding after reviewing the discovery and having a brief conversation with the complainant, there has been no contact since that time, physical, electronic, in any other way. So I don't know that a GPS tether is really necessary in this situation. And there was no allegation, even in the bond violation, that there was any physical contact. It was the leaving of a voicemail message.
Since I'm adjourning this and accommodating schedules, I will adjourn the probable cause conference to July 2nd, 2026, 9 a.m. With reference to bond, I will cancel the bench warrant. I'll reinstate bond with the previous condition, with his conditions. I will add a BS location correct together with an exclusion zone for the victim's residence.
But no curfew or anything of that nature.
No curfew.
Okay. All right. Thank you, Your Honor.
Thank you. Okay. Court calls case people versus Charles Johnson.
Overall, on behalf of Mr. Johnson. Johnson, please state your name for the record.
Charles Bernard Johnson, second.
Thank you.
And Your Honor, may we approach?
Really?
Just very brief, the judge.
Sure. I got Polly back on. All right. Court calls the case people versus Josiah Miller.
People.
David I. Goldstein appearing on behalf of the defendant. I don't see him on the Zoom, Your Honor.
I'm
Just-
sorry. Okay.
And Your Honor, this was Hillsdale, I believe, County Jail
Yes.
last time as well. So I do know that Mr. Goldstein has spoken with this client and he tends to wait. I don't know if the court will do it without him being here.
I can't.
Yeah.
Your Honor, I'm going to make a suggestion. I made it to Ms. Feltus, and we both agree it's not the best suggestion, but they're not going to honor a Zoom writ. So I'm asking you set this matter on July 2nd and have the prosecutor issue corporeal writ, have him brought here. Otherwise, I don't think we're ever going to get him.
I don't know, as you try for a writ, I would ask if you keep down on the week of the 4th of July, because we might have about a month. I know that there are going to be more staffing issues when we have a major holiday coming up. So if we could do the 9th.
10/9.
All right, let me
All right.
check that date you're in. Yeah, that's fine.
Turn it to July 9th, 2020. Bond continue.
Thank you. Your Honor.
Thank you, Ron.
Thank you. Court does call the case People versus Tanya. I'm sorry. Is it Naya Lee? I think.
Questions for the people?
Morning, Your Honor. Christina Costantino appearing with and on behalf of Naya Lee. Ms. Lee, can you unmute and state your name for the court?
Naya Lee.
Okay, thank you. All right.
Your Honor, we're asking for an adjournment of the PCC. There is a companion case with this case that is scheduled for June 22nd of this year. So we would ask if the court would consider adjourning this PCC to a date after that date.
Oh, it's set elsewhere on the 20th.
Yes, it's set at the circuit court.
Got it. Probable cause conference will be on June 25th,
That works, Judge. Thank you.
2026. Now, bond continue.
Thank you very much, Judge.
Thank
Have a good rest of your day.
Is that it for you?
That's it. I'm out of your hair.
Well, no. I just take the rest of these people with you. All right. Thank you. Have a great one. Court calls the case People versus Kyle Pennell.
Good morning, Your Honor. May it please this honorable court, David Burge, Kyle Pennell, who's approaching.
Your name?
Kyle Pennell, Your Honor.
Thank you.
Your Honor, discovery is complete. We're requesting to examine this matter.
Would people have their witnesses available the 16th?
We'll do our best, ma'am.
Preliminary examination in this matter will be set June 16, 2026, 9 a.m. before Judge Moore.
Judge, could I briefly address the issue of bond?
Certainly.
Thank you, Your Honor. Your Honor, bond's currently set in this matter at $500,000 cash surety. Understanding the serious nature of the charge, Your Honor, I have information that the victim in this case, the alleged victim in this case, not only was potentially the initial aggressor, tried to jump in my client's car. Car was the alleged weapon in this case, Your Honor. His injuries sustained were minimal. I think his toe might have been run over at worst, Your Honor. I have text messages from the complaint. He was at the casino the next night and was released from the hospital hours later. Understand, Your Honor, my client does not have a perfect record, but he's spent some time since he's had any issue. His fiance, Your Honor, who's pregnant, is present in the court today in support of him. They do both reside. He is employed. I'm asking the court to consider at least a reduction in the current bond, again, set at $500,000 cash surety.
Response.
Action.
Does he have what's his record like? Because I mean, I'm having some pause on this only because at arraignment, there was a substantial bond that sometimes in and of itself can be unusual.
Are you looking through the criminal history? Right?
Well, for some reason, his bond got set at $500,000.
No.
And Mr. Burgess properly so is asking for, in essence, a reduction or his release, but I'm not hearing anything from the people that is telling this court that a $500,000 bond is appropriate, and
This is where the $500,000 bond gets seriously questioned. Defense highlights employment, family support, limited alleged injuries, and circumstances surrounding the accusation. But the judge sees prior assaultive and firearm-related cases, plus a probation violation. That history changes everything. The court ultimately reduces bond to $100,000 cash surety. Still substantial.
but somehow at arraignment,
I wasn't present, Your Honor, but.
no, and I know, but the people were.
All right.
I'm trying to figure out why was this set at $500,000 if they're gonna leave it to my discretion, because
I see that there is a bench warrant for a probation violation where bond was denied.
so, okay.
And, the charges are assault, attempted murder, assault with a dangerous weapon. I am seeing, several cases within the last few years, not all of them have gone to adjudication. But that they are either assaultive or firearms.
Is he held on the,
Probation violation, Your Honor?
right,
Yes.
Your Honor, yeah, he does have a, I think he's held, but if he's able to post bond, he could address that issue with the sentencing court.
Bond was denied in that.
who's that before?
It was 14.
So his bond is denied out of 14B.
Probation Judge Washington? I think so. I'm not sure why, Judge. I mean, it's a misdemeanor matter.
Has he gone over, does anybody see a date scheduled for him at 14B? Thank you. And
You know, she's gonna have the answer.
so, so he's set to be seen June 25th. You have this on the 16th. His bond isn't gonna be changed there, but
Just facially seems excessive, Your Honor.
it stopped piling on.
Fair enough.
I'm gonna grant a reduction. I do consider this charge as serious, but he's not gonna be going anywhere. It seems at this point. I'll modify his bond. I'll modify it to $100,000 cash surety.
Thank you, Your Honor.
All right. Thank you.
All right. All right.
Court calls case People versus Joshua Hines.
Sherilyn Foster Tucker on behalf of Joshua Hines, who appears on the Zoom.
Mr. Hines, can you state your name?
Joshua Hines, sir.
Thank you.
And Your Honor, we're requesting an adjournment. I just got this case yesterday, so I still need discovery. And if I could briefly address bond.
So,
Your Honor, he does,
go ahead.
he currently, my understanding is that he's currently testing in Washtenaw County at Community Corrections. He lives in Shiawassee and is on,
County
yes,
does?
yes.
Should make her say Shiawassee. No.
And he's on probation out of Shiawassee County, and so he is hoping to get it so that he can test. He's testing in Shiawassee County and has signed a release of information. So he's hoping to be able to continue doing the testing there and not have to drive the hour to community corrections to do his testing here and repeat it.
Understood.
Yes.
I'll adjourn the matter to June 25th, 2026, 9 a.m. I will prepare an order for the
Okay.
court. I will sign off on an order allowing him to test in Shiawassee County.
Okay,
As they release information
yes.
provided to community corrections here so we can see the results.
Okay, thank
All
you,
right.
Your Honor.
Thank you. Court calls the case People versus Wesley Brand.
People.
Assistant Public Defender Dante Lebo for Ms. Brand.
Your name, sir? Wesley Brand.
Andrew, and I believed I had a green sheet, but it has went missing. Yeah, and we'd be requesting an adjournment order in order for Mr. Brand to review the video in this matter, which I received yesterday.
You received the video yesterday. He needs to see it.
Yes, Your Honor.
We get all that done by the 18th.
I don't see why not.
All right. Probable cause conference in this matter, June 18, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. MCM Shelter.
Court calls the case People versus Kelly Ott.
For the people.
Sherilyn Foster Tucker on behalf of Kelly Ott.
Hello, Your Honor.
Hello. State your name for me, please.
My name is Kelly Ott.
Thank you.
And Your Honor, we're requesting an adjournment. Mr. Bernstein is still needs discovery to review it.
That objection, I'll adjourn this matter June 25th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court
Thank
calls
you,
the case. You're welcome, ma'am. Court calls the case versus Shelby Barber.
Me, Assistant Public Defender, cannot be carried out really, Your Honor, on behalf of Ms. Shelby Barber. Mr. Shelby Barber.
When you know, all right.
Judge, I have not
If
made,
you walk slow and talk slow, that doesn't make them appear.
I was hoping something was gonna happen, but today's not the day. Your Honor, I have not been able to make contact with Mr. Barber. I'd be asked for an adjournment.
Bench warrant will issue for defendant failure to appear. Bond will be set to amount of 10,000 cash surety.
Thank you, Judge.
Court does to the people of state of Michigan versus Stephen Douglas Wainwright. Cases.
And that wraps a busy courtroom session filled with adjournments, bond disputes, forensic evaluation, missed appearances, and changing conditions. One defendant saw a $500,000 cash bond reduced to $100,000, while another missed appearance resulted in a warrant and $10,000 cash surety. Like, comment, and subscribe for more shocking courtroom stories.